Welcome to our audience tonight on Globespan 24/7. A very warm welcome to you, to all our viewers in Guyana and around the world. We are pleased to bring you tonight's program, Dialogue with You. Thanks to Noir Singh of Travelspan for making this platform available to us, and of course to Devin Bisu, our technical specialist. This evening, we are extremely honored and privileged to have, at the moment, two outstanding Guyanese. We expect a third one to be on soon to continue our dialogue with you. First, we have Mr. Timothy Jonas, Senior Counsel and Chairman of A New and United Guyana, Ms. Kim Kite, former State Prosecutor, Magistrate, and of course, we all remember her as GCOM Legal Counsel on the election matter. And we're expecting Mr. Sanjeev Dattadin, Member of Parliament. Currently, Parliament is in session, so we hope that when that is over, he will join us this evening. So, Ms. Kite and Mr. Jonas, welcome to dialogue with us on Globespan tonight.
Thank you very much, Mr. Sugrum. Good to see you again.
I know after a long break, you've been staying away from us. Ms. Kite, welcome.
Thank you so much for having me. I hope I can make some useful contribution.
I'm sure you will. And also with me is my co-host, Dr. Asquith Rose. Dr. Rose, welcome. Dr. Rose?
Welcome, Charles, and I hope you're doing fine wherever you are. And welcome, Ms. Kim Kite and Mr. Timothy Jonas. Greetings to the program.
All right. I'm still in New York, Doc. When I leave New York, I'll let you know. Tonight, we would like to engage our legal luminaries to discuss our current legal system, justice, and our Constitution. Each one of these topics can take days to discuss. So with the short time we have tonight, we'll ask our guests to condense their answers to our questions so that our audience can hear more from you of the many questions we have for you tonight. I'm aware that it will be difficult to ask attorneys to condense their talk, but I'm appealing to you to make your answers concise as possible. That's my humble request this evening. I don't think we need any formal introduction to our guests. Ms. Kite is well known as a former state attorney, a state prosecutor and magistrate. And as I mentioned, she represented GCOM chair at the election matters after the March election. And of course, Mr. Jonas has been a regular regular feature on this program, the Monday night and the Wednesday night program. So he is no stranger to our audience tonight. Ladies and gentlemen, I want to ask your first question based on what we're discussing tonight. And the question is our legal system working to the satisfaction of its users? We can start with Kim and then we'll go to SC. In your view.
Yes, this is what I'm going to say. Of course, you know, justice delayed can amount in some cases to justice denied. We have a number of delays in our system. I would point that out. So I'll start with the negative in the sense of course, you have persons waiting for some time on remand for the criminal cases to be tried in the High Court. We also have some persons who would have filed civil actions under the old rules, still awaiting hearing, hearing dates, trial dates. Obviously, members of the public, they're not satisfied with this, having had to wait perhaps 5 years, 10 years in some cases, before you could actually have a trial date. Having said that, where civil matters are concerned, after 2016, we introduced what is called the, called by a lot of lawyers, the new rules. Under these rules, you now have a faster hearing of civil matters. so that once you file actions now under the new rules, you could actually look forward for a speedy hearing date. We've had some issues, obviously, that it's not a perfect system, but I believe it is a system which is working. The other, I believe, the other amendment or the other introduction has been the family court rules, which has led also to divorces, which would have been delayed once they were contested. They would have been delayed for some time in the system. Even those divorces that are contested or defended, as we call it, even those divorces, because of the new family court rules, are being heard in a speedy manner. Division of property, custody hearings, you're having faster hearing, and so those are positive developments, and positive contribution to our legal system. So if it is working, I think the question is, if it is working to bring satisfaction to the users. It depends perhaps on when you would have filed your matter. If it was after 2016, then yes, you're getting a faster hearing. Prior to that, at least in the civil arena, some persons are still waiting on hearing dates. So obviously they would not find the system satisfactory, or they would perhaps say it's not working at all. So it really depends on those factors.
And Ms. Kite, before I actually ask you to come on, what do you think might have caused the long delay in those cases? And are they grandfathered in, or, are they transferred over to the new system? What is going on with those old cases?
They are being heard. I think in every county, judges are assigned to hear those old cases, and they're being heard. What has happened is that some courts should actually try to transition them under the new rules so that you're allowed to file witness statements, and these things all contribute to having a speedy hearing of the matters. So a serious attempt is being made, I believe, to have those old matters, even those old matters, for them to be tried faster than what would have, obtained under the old rules alone.
Thank you, Kim. And Mr. Jonas, as senior counsel, does that silk what you carry, does it give weight to ensure that our legal system works to the satisfaction of its users, to ensure, as Kim was saying, delayed cases and so on? What can you do as senior counsel to ensure, if what Kim said, I'm sure what she said is true, what can we do to ensure that the system works for the people who are supposed to be part of it?
That's an interesting twist to the question, Charles. That's like asking a doctor what can he do to make sure everybody's vaccinated, or asking a mechanic what can he do to make sure all cars are working on the road. When you're a cog in the wheel, you're a cog in the wheel. I don't think you can point to any single policeman to say what can you do to make sure no one ever commits crime in the country again. But I like the approach Kim took. I agree with her. You got to separate criminal from civil, and you also have to understand that people's expectations often are based on a misunderstanding of what takes place in court and what the purpose of the court is. The new rules were introduced in 2016, which really revolutionized the speed in which matters are heard and got rid of a lot of the old difficulties. But even under the new rules, I remember doing a matter in 2017 where from beginning to end, we had a full trial, and the client had a judgment in 8 months, which to me was proof of how well the system worked and how smoothly it was going and the efficiency of the judge. And the client still at the end of it said she would never do this again. It's not worth the effort. So sometimes people's expectations may not be realistic. The court is not there to help any one side. It's there to hear both sides. And you can't have a fair hearing unless you hear both sides. And that necessarily takes time. So once your expectations are realistic, I think that we have to give credit where it's due. We have the hardest working group of judges that I have seen in my years at the bar, led by the hardest working Chief Justice I have seen in my years at the bar. There are a couple exceptions. There are a few who still have the old culture, but for the most part, you have seen a complete change in the dynamic, a determination in the judiciary, which is where this has to be pushed, to get these matters moving, get them out, have judgments handed down so that litigants, whether they're happy or not, have a result of their litigation. A number of changes were made, which helps that along. The change in the rules, of course, meant that a lot of technicalities were removed so that clever lawyers were no longer able to point to some procedural defect and have your case thrown out. There is a much smoother and simpler process through the court system. Because a matter, once its file goes to a judge and stays with that judge, there's no longer kicking the can down the road for another judge to deal with interminably. It is in the judge's interest to deal with his matter so that it's out of the way, because it doesn't leave his desk until it's out of the way. So that's important as well. We passed an act called the Judicial Review Act, which, interestingly enough, was proposed and tabled before 2015 and needed litigation to be passed after 2015 because both governments in turn felt it gave too much power to the judiciary to review the actions of government. And that act has done a lot to help vindicate people who feel aggrieved by actions of the state, actions of the police, actions of the state bodies. That has been very useful. There also has been passed legislation to require that judges deliver decisions in 6 months. Well, that maybe has not been adhered to as closely as it should, but I would be the first to say that the judges have their hands full. You see, it's easy to talk about sloth, but if you have a complement of 15 judges for the whole country, where a country like Trinidad has more than twice that number, Jamaica 3 times, then you have to understand that you have to give the folk who are in the job the tools to do the job. And you simply do not have enough judges for what we're trying to do. If the Court of Appeal needs 3 judges to sit, and you have 3 Court of Appeal judges, it means you have 1 Court of Appeal to hear every single appeal filed in this country. You must have a bottleneck there, and you do. So you will wait years for your appeal to be heard. So it cuts 2 ways. The system has improved. Over the last 5 years, I can say for the first time in my civil practice, we are meeting the needs of the society. We are beginning to raise our heads in pride, but we need more judges. We need more Court of Appeal judges. And we also need for our judges to have security of tenure. We have an acting Chief Justice, we have an acting Chancellor, we have an opaque and misunderstood system of appointing and confirming judges. We have a dogfight as to how the Judicial Service Commission is to be appointed and to operate. So as soon as politics gets into the fray, it spoils it. And if we can separate politics from those processes, I think that the future looks bright in terms of the legal system in civil. Criminal is a different story. There are still people languishing in jail, in the lockups, waiting for trials. It takes too long. The sloth is apparent. The DPP's office still has the bad habit that if they do not have enough evidence to prosecute a case this year, they put it off to next year rather than acknowledging that they can't convict and letting the accused go. We still, in our judgmental way as a society, cry foul if somebody gets bail without understanding that the system is not there to lock up someone who hasn't been convicted. The system is there to ensure fairness for everybody, accused as well as victim. So the criminal side of things needs work, but it is certainly better than it used to be.
Very good. Thank you, Tim. And before I ask Dr. Rose to come on, is the same thing happening in the Magistrate Court as well? I mean, around the country, the same delays, or are they more efficient? You being a former magistrate, What is going on with the magistrate court?
The magistrates court, in terms of the civil matters, I believe they're heard faster. Because many of the civil matters are really landlord and tenant. Those are dealt with, speedily. The criminal matters, especially the serious ones like the preliminary inquiry and, perhaps the gun offenses, the narcotics, those can take some time. And again, too, you have to measure that against the fact you have one magistrate sitting and how many matters are being filed and, assigned to that magistrate. So you have to measure the workload of the magistrate with how fast justice is dispensed, how fast you get a decision and perhaps a sentencing or a dismissal of the case. So those are factors which have to be taken into consideration.
That's a great question. But before, again, sorry, Dr. Rose. I know judges have a system that helps them along the way in terms of writing their decision and so on. Does a magistrate have that, that help from?
No, as far as I know, unless the system has changed, as far as I know, the magistrates don't have any what we call judicial assistants in terms of research officers. In Trinidad, the magistrates, I know for sure, the magistrates have judicial officers attached to them who do their research and assist them. In the High Court, in terms of the High Court judges, I am not sure that every judge has an assistant either. All right, I believe a judicial officer, I could be incorrect, but as far as I know, I think they share. So if you have the judges already burdened with all these matters to deal with and decisions to give, and then, they don't have any or they have limited assistance in respect to research, these things obviously would contribute to delays because the judge has to do himself or herself.
So we have a long way to go. Dr. Rose?
Yes, good evening. Ms. Kim Kite, even though my colleague Charles said that you're well known, I don't think you're well known because I did not know anything about you before that case in the CCJ when you defended GCOM. Can you give us the background of yourself? Tim is already well known, so I will not ask Tim the same question.
I think your dear co-host did a good job. I've practiced as a state counsel. I was attached to DPP's chambers for about 3 years, and then I went on to the bench in the low court. That's the magistrate's court. I've been in private practice from 2007, and then I did a brief stint at the AG's chambers for about 18 months, and I'm back in private practice. I guess that's about it.
Okay, let me get straight to the Supreme Court. Somewhere I read the Supreme Court has 2 divisions, the Guyana Court of Appeal and the High Court. Can either one of you or both of you explain to our listeners tonight what are the functions of each of these systems? Start with you, Timothy.
Okay, if you go most of the Caribbean, you'll find they have 2 tiers. They'll have the High Court and then they'll have the Court of Appeal. In Guyana, we threw in a second tier, or middle tier. So we have the High Court, and the full court, and then the Court of Appeal. I think the intention, and ironically, we lose sight of this in Guyana because we've sunk so low. But back when we were one of the more developed countries in the Caribbean, and other islanders were coming to Guyana, and things were looking bright, it was recognized that the expanse of commercial activity and the expanse of litigation would probably increase. And therefore, a second tier, that full court, was thought necessary as a quicker appeal court where simpler matters could be dealt with. So, for example, there's something called a summary process. If I claim a sum of money against you, it doesn't need a long trial. Either you owe me or you don't owe me. So the evidence tends to be quite simple, can be determined quickly. And if a judge gives us what they call a summary judgment, which is without going into full trial, just looking at the paperwork and saying, no, you owe this money, that kind of quick disposition of a case is appealed to the full court rather than the Court of Appeal. So that second tier of appeal was intended to ease the workload of the Court of Appeal, which then could focus on appeals from the larger, more involved matters where there was a full trial. It has worked. What bogged it down for a space was when the full court became the court from which appeals from the magistrates were made. Because, of course, the magistrates, in terms of volume, deal with many more cases. And back in the days before the housing drive, when there were so many landlord and tenant disputes, all appeals where you granted possession against a tenant went to the full court. So the full court became bogged down and became even more slothful than the Court of Appeal. But in terms of a system, to have a full court that deals with appeals on summary, quicker, faster processes is a good thing. And that second tier of appeal is what we use. And as every Guyanese knows now, another one of the reform measures that were taken recently was the inclusion of the CCJ, the Caribbean Court of Justice, which deals with any appeal from the Court of Appeal. So we now have yet another tier of appeal, which essentially replaced the Privy Council that Forbes Burnham got rid of back in 1970. And I think is probably the best development in our judicial system, aside from the reform of the civil procedure rules in 2016, for the reason that it gives us access to an international flavor, an international culture, a group of judges who are have a much wider experience and are accustomed to working in locations which, quite frankly, are more efficient than ours, are more prompt and punctual than ours, and get the work done. And what happened, in fact, is that we were embarrassed by comparison, and we had to lift ourselves up by our bootstraps just to meet the standards that we saw in the CCJ. So along with the change in the civil procedure rules, that has helped the culture of the legal profession in Guyana.
Ms. Kite, you want to add anything to that?
Yes, I believe the introduction of the CCJ has been perhaps a reformation, you know. It has surely reformed our civil system and the criminal system, because you will notice that persons, even the criminal appeals, are being taken there. And, you know, this is a good development for us here in Guyana.
Okay. The magistrate courts are the largest in the country, and I'll hold your legal mind strictly to courts until we get to the Constitution. The magistrate courts are the largest in the country, but within the magistrate court system, I was made to understand that there are specialized courts. For example, a criminal court, civil court, family court, commercial court, coroner's court, juvenile court, traffic court, tax court, and drug court. Are all these courts functioning? If not, why? Ms. Kite.
I know some of the courts which you call are indeed functioning. The landlord and tenant court is functioning. Of course, the civil jurisdiction of the magistrate court functions, and the criminal jurisdiction. There is also a drugs court which was started recently. As far as I know, that is functioning also. We also have the juvenile court, which has been active and functioning. So as far as I know, most of the courts which you call have been functioning. I'm not too sure about the tax court. I don't know, Timothy may want to deal with that. I'm not too sure about that one. But most of the other courts which you call, they're functioning as far as I'm aware.
You, Timothy, why do we need a drug court in Guyana?
Drug court, you say, Euclid?
Drug, yes. That's what I read.
Well, there's no specialized narcotics legislation that there didn't used to be long ago to meet the evolving needs of the society. I have a view about it. I think that our narcotics legislation needs to be revised. needs to be revisited. Our problems in that area are different from the problems faced in the first world, and I think that the legislation needs to be geared specifically to deal with our problems. We're a transshipment area. We're not a consumption area. And the legislation needs to target where our social problems are and how to fix our problems. But because there is specialized legislation and because of the prevalence of the crime now, there does need to be a specialized court. And I know that in Georgetown there are areas, but I am not a criminal lawyer, so I'm going to ask you not to press me for more detail on it.
Okay. A few weeks ago, President Granger said that the CCJ should not be involved into Guyana's election process because it's an internal process. It should end at the Caribbean Court, the Guyana Court of Appeal. Do you agree or disagree? Mr. Jonas, you first.
Well, that's utter rubbish. Back in 1970, in a case called Brands and the Attorney General, the applicant sued the government, which was then run by Forbes Burnham, for wrongly acquiring property without giving fair compensation. And this went all the way to the Privy Council, which ruled that the government had acted unlawfully. Now, no one can say that the Privy Council, those judges sitting in England who have probably never been to Guyana, were influenced by politics in Guyana or sided PPP or APNU. These are independent judges doing the job up there, but the government of the day didn't like the fact that they were independent judges who would hand down a judgment without fear or favor and regardless of political preference or persuasion. And therefore the response was inevitable. Mr. Burnham removed the Privy Council as our last court of appeal. He made the Court of Appeal a court which he could control because the judges are appointed by the Judicial Service Commission, which at the time were appointed by him. He made that the final Court of Appeal. He removed the then Chief Justice Laku, who he saw as too independent a figure, and replaced him with somebody else. And since then, during the 70s, we saw a Court of Appeal, or a final Court of Appeal, that had the Congress Place flag literally flying overhead at the gate. Now, that is an unacceptable situation. Judges must be independent, the court must be independent, and if there is any taint or appearance of political persuasion, there is a problem. So the best thing that has happened to Guyana is the advent of the CCJ. I challenge any Guyanese to say that the judges of the CCJ give a damn about politics in Guyana or favor one side or the other side or are anything other than independent souls applying the law. And the same cannot be said with the same safety, with the same confidence at lower levels, because anytime a judge gives a decision in Guyana, half of the country will rampage that the judge is politically biased, and the other half will say the judge is wonderful. But you don't get that to the CCJ. So for any leader of this country to say that we must remove the CCJ, which is exactly what Burnham did back in 1970, is alarming and needs to be opposed at every single step.
Ms. Kite?
I obviously cannot agree with that statement. I believe the CCJ gives a kind of independence to decision, or independence in their decision making, which Guyanese really should treasure. Tim is correct that sometimes when we see decisions coming from our own courts, you have the back and forth and, who is somehow affiliated with this side or that side. The CCJ brings to that, or brings to the decision-making process, independence, because it would be difficult to point to any of the CCJ judges to say that they're somehow affiliated with one political party or the other. it gives us, as Guyanese, that kind of confidence, or I should say, more confidence in the judicial system and in judicial decision making. I believe it is one of the best things which was done in respect to our hierarchy of courts, to place there, another level for the testing of the decisions by our lower courts. All right, so I certainly cannot agree with that statement. I believe the CCJ has been, and when you look at their decision making in respect to Guyana, this has been an excellent development.
Having said that, both of you have tried several cases in front of the CCJ, most recently last year during the election saga. Do you think the CCJ judges are biased? That has been the opinion of some, or they're naturally fair and rule and apply the law according to the Constitution? You, Ms. Kite.
I have found them to be fair. I have dealt with quite a number of matters before the CCJ. I have found them to be fair. They have not ruled in my favor at every decision. I've had some unfavorable decisions by them. But I believe that they apply the law as they see it. And that is a final court. And I've had to accept those decisions because that is a final court. So I've never found them to be biased.
Mr. Jonas?
Oh, my good friend Ms. Kite is very modest. Most lawyers will say when the court disagrees with them that regrettably the court has been sadly mistaken. But I agree entirely with what Ms. Kite says. Appearing in the CCJ is an experience that is different from appearing before the local courts. You can have 5 or more judges asking you questions. The interaction is wonderful. At the end of the day, you get a decision that is sound. I have written articles disagreeing with their treatment of land law in Guyana. And you will not always agree with them. That's fine. But one thing you can never say is that a decision is given that goes against a logical argument. Any decision they give, they can defend. It's solid, it's legally sound, and you may not like nuances, you may not like trends, you may not like the reform, but it is an excellent court, and it has transformed the legal system in Guyana. And it would be a tragedy to think that that court could go.
Mr. Charles Sugrim, over to you.
Ladies and gentlemen, we want to take a short commercial break. This is a very interesting. Kim, Timothy, what you mentioned there about the days of Burnham controlling the judiciary, I want to come back and address that a little before we move on. So we'll be back shortly after a short commercial break. Just stay there. Thank you.
Are you ready for the first ever Travespan Curry Duck Curry competition in Punta Cana, DR, along with cricket and Tassa, brought to you by Travespan, allforonesupplier.com, Dave's West Indian and Abby Tunes Radio. Your all-inclusive getaway includes non-stop flights, 4 nights hotel, resort services, unlimited food, drinks, and exciting live entertainment, including Tassa, Marissa, DJ Sean, Randy, NRTG, and me, Terry G, the Bangali Babu, alongside surprise guest performers. Call Travespan 212-243-0865 or book online at travespan.com. Punta Cana, Dokore, Punta Cana, Corridor, get on fire!
All From One Supplier has all your favorite meats and fish. We also have lamb, bangameri, goat, hassa, blue crab, butterfish, kingfish, snapper, and much more. In addition to our meats and fish department, we also have halal meats. So shop online today at allfromonesupplier.com with free shipping within the United States for all of your regular meats, fish, halal meats, and West Indian items. Globespan 24/7 continues its efforts to serve the communities. The platform provides for all sides to air their views and discuss solutions. Viewers in Guyana and across the world are participating in these discussions. Globespan's platform offers Guyanese an opportunity to express their concerns and discuss solutions in the political realm, thereby addressing the polarized situation. Discussions also include social ills, such as alcoholism, domestic violence, and suicides that have been plaguing the people. The Globespan 24/7 platform connects the diaspora and the world with Guyana. So become a supporter of Globespan 24/7 today by clicking the badge icon on the lower right side of your screen. For only $10 a month, you will be a supporter of Globespan 24/7 initiative and have a badge displayed on your Facebook profile. Help us to continue to serve the communities.
Okay.
Welcome back to our audience. We want to thank you for staying on with us as we have two distinguished luminaries in Guyana, Senior Counsel Timothy Jonas, and of course, former Magistrate, Ms. Kim Kite. Gentlemen, ladies and gentlemen, before we went off to the break, Tim, you had mentioned in the Burnham years that they were judges, well, Burnham appointed judges, and in some cases, on political issues, they rule, of course, in favor of the PNC. But overall, were those judges outstanding judges as well?
Well, Charles, I think you misquoted me there. I don't think if you check back the recording, you'll see either that I said Burnham appointed judges or that they gave political decisions. I don't think I said either of those things.
No, that's my statement to you.
But if that's your contribution, all right. What I will say is that the judiciary in Guyana has always been intellectually at the top of the Caribbean. We got bogged down in a few issues. We got bogged down because of the sloth in the system, and unfortunately, the judiciary were not astute to push the system so that we had the backlogs which required the change in 2016.
We have lost Tim there. Tim, you're Devin?
Just give him 1 minute to reconnect.
To erode the independence of the judiciary. One example, you see, you don't need the stick, you can use the carrot. You give national awards, Order of Raima, Crown of Honor. You give duty-free concessions and chauffeurs. You have, besides national awards, you have national events and perks and that kind of thing. So there are ways to induce friendliness, and then there are ways to threaten. We had a situation years ago, for 2015, when we had to force the government of the day to confirm two judges into their position. They were acting judges. An acting judge is a person who's at risk. He can be fired at any time. And if a judge doesn't have security of tenure, then he is more susceptible to influence. You cannot have acting positions in the judiciary. And yet, as you know, we have had acting chancellors and acting chief justices for 20 years now. Now, that is unacceptable, and yet we accept it.
And we'll come to that. I'm glad you cleared that up with me, Tim, but let me get into this question now. And I want to ask both of you, what would you consider the most serious problem facing the country? And if you had the resource available to you, what would you have done to solve that problem if there is a problem? Ms. Kite, can we start with you?
I will ask you to repeat that question, the first part.
What would you consider the most serious problem facing our country?
And this would be in terms of
whether it's legal, political, social, whatever it is.
Oh, that's a hard one, because I think we have so many issues. So what I would consider to be the most serious one.
What about domestic violence? Domestic violence?
Violence is present, yes, but you know, to me, some of it may be political, in the sense that, during the last elections, that was a very difficult time in the aftermath. That was a very difficult time for Guyana. And there are certain political issues which I think must be addressed. So that is serious. Of course, the level of crime is another serious issue facing Guyanese. Of course, we're also still dealing with the pandemic and the consequences of that. And of course, within recent time, we've had to deal with flooding. So there are so many issues that I believe are very serious. Which would require, in some cases, may actually require for us to perhaps even our laws. In some cases, I believe we may need amendments where some of the issues which we saw flaring up after our last elections that may call for certain types of amendments. So to me, there are many. There are many issues where the violence and where the crime is concerned. That will call also for perhaps intervention in some cases at perhaps parliamentary level. Timothy did mention in terms of the Narcotics Act, we may have to look back at at some of the offenses and how we categorize it and how we determine bail for those offenses. So it's many problems.
Too much.
I
Right?
would consider.
And I'm sorry I hit on it so hard. But Tim, is there any one problem you think facing our country that need to be addressed? And if you had a resource, what would you do to address it?
What a question. Charles, everything in life is about you and money. So every policy has to do with improving the life and improving the state of the pocket of our citizens. Everything's about money. The ancient Greek philosophers said, and it's true, that if you give a man a house and a wife so that he has something to protect and a farm, he's not going to go out on the road and riot and kill and steal. When other people are rioting and killing and stealing, he'll be home protecting his house and his wife and his farm. And I think that's very important. We have people who are dirt poor and who get no relief from the state. We have people who are educated and can't find jobs. We have people who are struggling and are taxed out of existence. We have people who are sick and can't get medical care. People who are old and can't get NIS or have to line up every month interminably for some pittance at the post office. We have to fix those social structures so that people have hope. So if you're asking me what I would do, there's a lot that I would do. From the smallest thing, let's start with the small things. Charles, this needs more than an hour to talk about.
I know.
We got dogs, cows, horses running around on the roads. Now, that's just one aspect of how our society has deteriorated, and we haven't even been able to maintain the standards that the British left us. We have laws on the books that require you to have a license for your dog, a brand for your cow or horse, and to have dog catchers and animal catchers who get money to find animals that are straying or animals that are not licensed and make it worth their while. So we need laws that if you got a dog, you must have a license. You must pay $10 or $20 or $30,000 a year for that license. So it will make sure that you got your dog spayed, well treated, and under control. It will also mean that you have enough money to pay the animal catchers to catch the stray dogs so that people not running into them nighttime like we saw at Fort Wellington last night. Small things like that. And then you got big things. We got foreigners coming into the country doing jobs. That's well and good because they have the expertise. But we talk about local content and have no idea how to treat with local content. We need a separate tax structure so that a foreigner pays a different tax regime than we pay. If an engineer who's coming from abroad to work in oil and gas has to pay 1/3 of his salary just for his visa and then pay income tax, the Guyanese engineer is competitively at an advantage because he doesn't have those extra burdens and he can compete advantageously and get the job. So the tax structure needs to be reformed. We got to get rid of this sense that our politicians are some deities who can drive around in luxury vehicles, while we have to drive 1500cc economy cars. So we have to change the tax structure on vehicles. That will encourage business. Businessmen won't have to go to the government to ask for a tax break so that they can make the investment. Because as soon as a businessman has to go to ask for a tax break, he is subject to the whims of the government and there's unfair and unequal treatment. Charles, you asked a question there that requires 3-4 hours to answer. So I've only given you 3 examples, but I can go on if you're patient.
And I think you and Kim handled it really great. I know we can go on and on, that's true. I want to ask you, this is a yes or no question. To you first, Kim, have you ever contested an existing contract before the court? Have you contested an existing contract before the court?
Yes.
Yes. Mr. Jonas?
Are you getting the ExxonMobil, Charles? Because that question is not legally framed. When you say contest a contract, are you saying the contract doesn't exist? Or
no, the contract is signed. The contract is signed between. No, the contract is signed between 2 parties, and you contest with one of the parties. And the answer is yes. Okay, and just very clever, Tim. That is very true. I'm coming to that because there are several debates that a production sharing agreement with Exxon and his partners and the government is a really flawed contract. In the legal terminology, and both of you are astute lawyers, it speaks of contract that is one-sided. Its legal term is called unconscionable agreement. And both of you are unfavorable because terms are outrageous. Does this give us the legal ground to terminate the contract with Exxon? I know Tim mentioned this earlier, that contracts are, need to be kept, but we know every day in the courts, contracts are contested. Is this contract unconscionable to the Guyanese people? Kim?
That's an extremely difficult question. Why I say it's difficult? For a number of reasons. I don't like to comment on things where, I haven't, for example, I haven't read the entire contract. I'll be frank with you. I haven't. And for me to comment on it, obviously I'll be commenting from some of the excerpts I've seen in the newspapers and other persons commenting. If some of those comments are true, then of course, perhaps some of the clauses are unconscionable. If that is so, then they could very well form a ground for it to be contested. But then again, I'm saying this against a background where I haven't studied this contract. So I would be in a much better position, if perhaps I study it. But you have to bear the contract. I haven't, I haven't studied the contract. But of course, I think, when contracts, one of the disadvantages or one of the issues, perhaps, if we attempt to challenge that contract, obviously there are certain factors which the court would have to consider. the bargaining powers of the parties, whether the parties had equal bargaining power at the time. Obviously, the fact that it's a signed agreement, and one of the principles in contract law, generally, you're bound by what you sign. But there are exceptions to those rules. And, one of the exceptions would be, of course, if you had issues of duress, you had inequality of bargaining powers. These are factors which the court would take into consideration. But I believe that the contract should be studied and should be studied closely to make that type of determination whether it should be challenged or not. All right, I'm not saying that it cannot be. I certainly don't believe that because, I have challenged contracts and, I believe it is something which can happen. But again, we should study it and, make that type of decision, I believe, at another level.
What say thou, Mr. Senior Counsel?
I'm afraid this time I got to disagree with the premise that Kim uses. There is a principle in contract law that a minor, a child, can't be bound by a contract. So if you sign up a contract with a child and the child does not comply with the terms of the contract and you sue, the court will say that a child can't be bound by the contract. And that is clearly just and fair because an adult can easily take advantage of a child. Now, I'm an adult and Dr. Rose is an adult. And if I have a $5 million car and I agree to sell it to him for $1 million, how on earth can I come back later on and say, I no longer want to sell to you for $1 million. I changed my mind because I now think the car is worth more than $1 million. We've entered our contract. I've agreed to sell for $1 million. He's agreed to buy for $1 million. And we're bound by that contract. I'm an adult and he's an adult. So are we saying that Rockwell Trotman and company and the government were children? I would be embarrassed on behalf of Guyanese to try to argue that some company had duress over us or more knowledge over us, or that a whole government did not take the time to understand the contract, read the terms, get expert advice if they needed it, so that they signed a good contract. If you sign a bad contract, you're stuck with your contract. And I don't see a way around that. Now, that being said, government always has a lot of leverage. And there are often legal, lawful ways to achieve the desired end result without going back on your contract. So it may be that a tax regime can be introduced. VAT, for example, VAT on sales of oil. Oil is something sold in Guyana. Is VAT payable, or is that one of the many things that we have agreed to forgive in the ExxonMobil contract? I don't know the answer to that. But there are so many tools in the arsenal of the government of any country to achieve a fair result without chasing away the other investors who are looking to see how you are dealing with this main investor, because that's also a consideration. We have a bad reputation as a country for how we deal with our foreign investors. And we have the whole country, many of whom have not read the contract, have not understood why we signed a bad contract, clamoring to say we got to get rid of this thing without understanding the deeper repercussions of that kind of arbitrary talk. So you are not a child, you signed a contract. See what the terms are, honor the terms, and then see how you can achieve the end result without breaching your contract and without running afoul of your obligation. We signed a bad contract. We need to blame our leaders, because our leaders were adults that we put there to look after our interests, and they manifestly failed to do so. But we can't blame the other people who were negotiated to get the best deal they could get. That's their job.
I want to be devil's advocate now. A contract also is not enforceable if the one party is impaired or the other party but you know the word in Guyana we call drunk. These guys were drunk with power. They signed a contract that is unconscionable. I know those are not, I don't think we can prove that in court, but I think, as you rightly said, my point to you now, Tim, is that having seen what we did in the past, should all contracts for exploration and for these huge contracts first be approved by Parliament, and we're getting now into the new constitution, should the Parliament first have a yes or no vote on any contract signed with foreigners? What should that be in our new, should that be part of our new constitution? Kim, we can start with you.
That would obviously be a good amendment to the Constitution, you know. But I think going back to the contract, I think it has opened our eyes as Guyanese about the seriousness that we should place when we're going into these negotiations. And this is beyond negotiation. This is now a contract, you know, a binding contract. And as I said, it's difficult when you sign these agreements to really get out of them. And I believe it's an eye-opener to us as Guyanese to treat with the resources of our nation, all right, in a very serious manner. This is not your personal transport, you know, or your title that you can do as you want with it. And even if it calls for, and these matters should not only be dealt with at a political level, in the sense of, you know, whoever is in power, something as serious as our resources, parties should be called in the sense of, you know, technical persons, excellent contract lawyers, to review these things, because at the end of the day, you are binding a country. This is not a personal arrangement. You are now binding a country, and then it becomes difficult when the consequences flow and follow. Because I think one of the things that Timothy and I can agree on is the fact that it would be difficult to escape the consequences of, you know, a signed agreement. There may be escape routes, but it would be extremely difficult. So, you know, going forward, whether it is we need parliamentary intervention, when certain types of contracts are being, you know, the government of the day may, you know, want to pursue certain types of contract. If it is that we have to amend the Constitution to put certain checks and balances in place, whatever is needed, as a people, I believe, as a people, there should not be one political party. As a people, because we're all seeing the consequences. As a people, we should unite to ensure that we put the requisite checks and balances in place to ensure that we will never enter into a contract which can have these unfavorable consequences for us ever again. But that could only happen if we unite as a people.
Thank you, Kim. Tim, should all exploratory and foreign contracts or agreements be first ratified by Parliament in a new constitution?
Charles, every time that kind of suggestion is raised, I have to ask the question, how do you propose to achieve that? You want to change the constitution, where are you going to get 2/3 vote from? Where are you going to persuade?
Well, we do it like 1978, a referendum.
Do you know how to do that? How do the 6 people on this panel, 5 people on this panel, go and have a referendum?
That's why we have you and Ms. Kite here tonight to tell us that.
You don't do it unless the powers that be decide to do it. So if you want to talk about changing the rules, you got to go to the people who made the game, and the people who made the game like these rules. So as soon as someone says, let's change the constitution, let's change this, let's change that, my question is how? The people who are in power like the rules. You see, we talk about the ExxonMobil contract. But ExxonMobil isn't the only company that was given oil blocks. And when people forget about companies like JHI, who quietly got oil blocks, other companies who got and resold at a profit, companies that had nothing to do with oil, but got a kickback, got a favor, resold, made an enormous profit, quietly disappeared. And this is done because the minister at the time, whoever the minister was, could make that decision on his own without oversight, because the powers that be like it that way. That is why we found out about $20 million signing bonus after the fact by accident. The powers that be, even after that change, liked it that way. So who in this forum is going to call a referendum, and who in this forum is going to procure a two-thirds change of the rules, a two-third majority so we can change the rules? If we're trying to talk about that, then we tilt in at windmills. We got to have some achievable targets.
And you've hit the nail on the head there, Tim, because the coalition in 2015 campaigned that there will be constitutional reform. We know where that went. Nothing, nada. The PP campaign in 2020 that there will be constitutional reform. We are approaching the first anniversary, and all we are hearing is that a bill will be sent to Parliament to begin the process. So my question to you before Dr. Rose comes in, do you think we will have, I know you answered the question just now, Kim, but maybe Ms. Kite can answer the question. Do you think we'll have any meaningful movement towards a new constitution if there is ever a change or amendment or a new constitution? Ms. Kite, what is your view? Again, Tim has mentioned clearly, if the two sides don't agree, there's nothing going to happen. And in my belief, I believe what Tim says too. But what do you say?
For the Constitution to be amended, obviously, you would need the involvement of both sides. Certain parts of the Constitution, they're so entrenched that you need a two-thirds majority. So in some cases, you need a referendum. All right, it's only some cases that an amendment could happen by a simple majority. So you would actually need, for us to have these types of constitutional amendments we're talking about and alterations, you actually need both sides of the House to work together. And that is what I was hinting at when I was talking about, certain types of contracts like Exxon and so. You would actually need our politicians to come together and work. All right. And I don't know how possible that is in the near future.
You're muted, Charles.
Yes, sorry. Tim, you want to expand, or you said enough of that?
I think we have very specific examples of why the two sides will never agree to anything meaningful. The last time there was constitutional reform, it was because there was protests in the street, the economy had closed down, and the parties were forced to it. But even having been forced to it, what constitutional reform took place? One change was the president can only sit for 2 terms, not more than that. That was eagerly accepted by both sides because both sides got young, ambitious party members who want to be president. They don't want to see Chetty and Janet sitting down there for 20 years. They want their turn. So they got their way. You have to look at the motive and the reason for these changes. We will see constitutional reform. You know what we're going to see? I'm going to call it no, and I'll place a small wager if you wish. The reform will be that a member of parliament who has been appointed by you or by the leader of the opposition may not vote against your wishes unless he informs you first. He may not cross the floor, because that act of treachery decentralizes power and is worrying when the split is so narrow. Because even today, all you need is one man to cross the floor, one woman to cross the floor, and you have all hell breaking loose. That will be the constitutional reform. Not for the good of the country, but to ensure that power is consolidated within whichever of the two parties is in power. So let's see if I'm right about that.
Okay, Dr. Rose, you have a lot of questions on constitutional reform. Let's go.
First of all, I strictly want to disagree with Mr. Jonas. in terms of animals. I'm an animal lover. Leave the cows alone, let them walk the face of the earth any place wherever they want to walk, and do not impound them. We do not impound people for walking the streets, and you tell me a dog needs a license. Do we give ourselves license or give our children license? So leave the animals alone and don't impound the animals is taking away the human rights or the animal rights. So leave the animals alone. They're free to roam the earth. End of story on that one. Now, I want to go back to the Constitution and the judiciary and the legal system. The Constitution provides for 3 independent branches of government: the parliamentary, executive, and judiciary. But many have contended that over the years, the judiciary is not independent. There's been judicial intervention or interference by governments. Ms. Kite, do you agree with that statement?
Let us be frank. A lot of times when persons make these contentions, they make these contentions when a decision may not be in their favor. All right? Sometimes persons, they make these comments without any proof, without any, corroborative evidence. So I can't agree with such a bold statement. Perhaps in some cases it has happened, but that is why we have decisions being tested at different levels. And that acts as a safeguard. The magistrate's decision is tested, the judge's decision is tested, either at the Court of Appeal or at the CTJ level. These things act as judicial safeguards. So in the event that someone was influenced, you still have the appellate process upon which you can rely, to have an independent court. If you feel that the court which heard your case wasn't independent, an independent court review that decision. But a lot of times, Dr. Rose, you would see people making these statements in the press, but then you have to ask yourself, do they have the requisite evidence to support what they're saying? So we have to be a little cautious about, some of these statements. But again, the system doesn't leave you like that. So that if you have the proof and you feel strongly that your matter was not dealt with in an impartial manner, then of course, test it. I always encourage persons, if you feel you have a strong case upon which you can appeal it. Appeal it. Another court may have a different view, and these are the safeguards which I think, we have in place.
Mr. Jonas, I'll give you a different question, and Ms. Kite, you can come in after. Looking at the racial divide in the country, presidents appoint justices, chief justices, and chancellors, and so forth. But do you think those appointments should be made in Parliament by 2/3 majority? So that not because you have 1 seat majority, you can go ahead and appoint that person, but by 2/3. This means that both parties, all the parties have to agree in order to vote and accept that judge or justice. Do you agree with that?
I think that it's possible to be too bureaucratic, Euclid. And again, before this program started, we were talking about our parliament. And if you got 33, then what are we agreeing on? I might as well stay home. So to put added pressure on our parliament in the 2-party system, where the majority government, no matter how much you protest and fight and quarrel, at the end of the day you vote and they win, you haven't changed much, have you? So I agree with you. We need a system of independent selection of our judges. And that is clear. For me, in terms of promotion of the judges, advancing the judges professionally once they are already judges, I think perhaps that could actually rest within the legal fraternity itself. Perhaps, in the States, as you may know, many of the judges in the different counties are elected. Maybe it's for the judges themselves to decide which of them they would like to see as Chief Justice, which of them they believe should go up to the Court of Appeal. It certainly shouldn't be on the basis of seniority alone. But within the profession, we know who's good. We know who's deserving. And Kim is right. outside of the profession, and I'm sorry to say it, but it's the truth, and I'm not going to mince words about it, there is not that level of discernment. And there are often baseless allegations, baseless accusations made by someone who didn't like the decision. The thing with a court, and this is what people miss, a court is conducted in public. Anybody that wants to see what's happening can go and sit down. They can see the evidence. Both sides are heard. Both sides have the right to representation. In fact, in criminal courts, if you can't afford a lawyer, the state provides a lawyer for you. It's hard to make an accusation of unfairness, of secrecy, of arbitrariness in a situation where both sides can be heard. The entire public can sit down and watch what's going on, and then both sides can be represented. If our elections were like that, were that transparent, they wouldn't have lasted 5 months. So we should be careful about casual criticism of the judiciary. But certainly once the method of appointment is fair, we could leave a lot more of that process within the legal fraternity itself. I would like to see that.
Ms. Kite?
I certainly agree. We can indeed review the process for election of judges, and even the how or the manner how we choose our Chief Justice and the judges for appellate level. I believe that system can indeed be reviewed, and perhaps better systems put in place for that.
Both of you alluded to this before. For the past 23 years, not a single Chief Justice or a Chancellor has been confirmed in the court. They've always been acting. Why?
Well, Euclid, that is one of the wonderful changes that was made with the constitutional reform back in 2001. You see, we talk about constitutional reform and we lose sight of the fact that the politicians negotiate these changes for their own ends, for their own means. Neither side wanted to lose control of that power of appointment of the judiciary. So one of the amendments, one of the reforms, was that instead of just consulting with the opposition, the president couldn't appoint those two officers unless he had the agreement. So he never got the agreement. And there hasn't been agreement on the subject for 20 years. Yeah. As long as you have political interference in the judiciary or in the legislature, you will have a mess. And in Guyana, we have a mess because the politicians have centralized the power and they're not letting go.
Ms. Kite?
Yeah, it is the very reform which we were talking about, which brought about that change to the Constitution. So now there has to be agreement. I don't know how we're going to have that, unless there is serious consultations and discussion, and our leaders actually plan, to ensure that they would not allow this type of situation, which is, I don't have the words to describe how, unsatisfactory this is to the members of this society, that we only have these two officers acting appointments for as long as very, very long. And this is something which I believe the politicians should try to sit down together and deal with. All right?
Okay. I had this question prepared for Mr. Datudin, but I think I can ask both of you. And I have individual questions for all of you as well. In 2019, Mr. Datudin said that in order for the court to be more efficient and effective, a number of administrative deficiencies must be addressed. Do anyone of you know what are those deficiencies, if there are any? Mr. Jonas?
Well, speaking as a civil lawyer, as I said, we've already seen a radical reform and a tremendous improvement. Now, speaking in 2019, a lot of these changes had already been implemented, although possibly the full beneficial effects hadn't yet been felt. But for me, the ones that I mentioned, the change in the civil procedure rules, the introduction of the Judicial Review Act, the introduction of the CCJ as the final court of appeal, those were of fundamental importance. And what we need now is a larger complement of judges, both in the High Court and in the Court of Appeal.
Ms. Kite?
I'm sorry, Mr. Dattadin is not here to perhaps expand on exactly what he was referring to. But you know, as I've said earlier, we've seen some improvements within recent years. Obviously, I believe we still have a far way to go. You know, some issues still remain, even with filing in the registries. Sometimes the length of time that you actually have to wait to have, you know, an estate grant typed up. Simple issues like that. These are things I believe that we can improve and work on. But we have seen, the fact is, we have seen improvements within recent, from 2016 to now, we have seen quite a number of improvements. And I really compliment the judges and the staff, you know, because they have had to adjust to change also, and you know, and lawyers and litigants, we're all adjusting to changes. And you know, we have seen improvements.
A 2009 law gave judges 120 days to hand down their decisions. But in most cases to date, most justices or judges have not complied with that statutory law. And there has been no consequences. What do you think? Mr. Jonas. Okay, Ms. Kite, go.
I was about to say that obviously that is not an acceptable state of play for any litigant. Let me start off by saying that it is not acceptable, it is unacceptable. Persons want to know after their matter has been tried and within at least a reasonable amount of time, at least within the time provided by the Act, you know, a decision should be received. But again, you have to juxtapose that. You have to measure that against certain factors. Like one, what type of support does a particular judge have in place? Does that judge, is there any judicial officer attached to the judge, any judicial assistant, any research officer attached to the judge to assist them with their research? Are those, you know, systems in place? How many auditors, you know, the particular judge may be dealing with at the same time? And then we have a system in Guyana. We don't really have specialized courts like that. A lot of these judges are doing both civil and criminal. So they may finish their civil, you know, period. It might be for a quarter. And then they leave with, they've heard all the, you know, evidence from 20, perhaps 30 different cases. And then they're thrown into the criminal assizes. All right, so they now have to take their focus away from that, deal with the criminal matters. When are they writing these decisions? So, you know, these are some of the issues I believe that we have to balance or we have to weigh and consider when we are looking at this issue of how soon after decisions come out from our judges. I believe, you know, we have to be fair and we have to take all those issues into consideration.
Mr. Jonas, there's a question for you. In April 2020, you were appointed a senior counsel along with Jamila Ali, Roysdale Ford, Marceline Bacchus, Stanley Moore, and you filed a court order to squash the senior counsel appointment made by President Granger. The matter was tried and the court ruled against you. But do you honestly believe that senior counsel should not be appointed by a president or by the judiciary and the bar?
I didn't expect that question, and I'm glad you've asked it, because I haven't really had an opportunity to explain what that was about, and I find that a lot of people have accidentally and some deliberately misconstrued it. Here's the thing. As you know, I always advocate for decentralization of power. We've just talked about political influence on the judges, politicians being able to give judges honors and perks and that kind of thing, or to withhold perks by not confirming them in office. Any power that the politicians have over the legal fraternity is a bad thing. I want to say it again. Any power that the politicians have over the legal fraternity, judges and lawyers, is a bad thing. So when Granger demonstrated that he was just as bad and probably worse than all his predecessors in terms of determination to interfere where he shouldn't, I took the step and I deliberately waited until I had been appointed and then disappointed, as you know. So I didn't want to do it when someone else was involved. I wanted to do it when I was involved. To go to court, to say to the court, shouldn't this process be within the province of the judiciary rather than in the province of the politicians? We have experience, and we just spoke about politicians trying to appoint friendly judges and favor friendly judges. But isn't it just as dangerous for politicians to have that carrot over lawyers to elevate friendly lawyers and disappoint unfriendly lawyers, so that the whole system is corrupted? And the purpose of my action was not to threaten anyone or to undermine anyone. The purpose of my action was to give the court an opportunity to say, this is the province of the judiciary and the judges have the power, and it is the decision of the judges on the appointment of senior counsel that has the legal effect. I was disappointed with the outcome, but I can tell you that one of the reasons I have abstained from criticizing President Irfan Ali too loudly is that when he called me to ask me, Granger having done what he did, if I would accept Silk, I told him no, not until that case was decided, because my case was pending before the court on the question of whether it is the judiciary or the politicians who have the power of appointment. And I could not accept from him, a politician, when I was contesting that it needed to be from the judiciary. And he told me that, first of all, he would await the outcome of the case, which is the one condition I made. And second, that he wouldn't do anything else until the case was decided. So that he also said that he would get the approval of the judiciary, because the second condition I gave him was that the judges got to approve my appointment. And he was true to his word. He called me back to say that the judiciary had agreed and approved my appointment, and for me that was a personal condition. I don't know about anybody else, but the judges got to say it, and they did. And then he waited for the outcome of the case, and I in turn told him that whatever the outcome of the case was, once those conditions were met, I would turn up and I would accept the appointment. He demonstrated he was gracious, he demonstrated he was true to his word, and although I do not support his party, I give him credit for that. And I in turn had to honor my word and do what I did. So it was about trying to remove the power of politicians from the legal fraternity. And I was disappointed with the decision, but I kept my word and I abided by it.
Ms. Kai, this question is for you. You said in 2001, my country has always been a priority for me. And this was instilled in me as a student at the President's College. You have 2 master's degrees, one in criminology and the other in criminal justice. You have been a state prosecutor, a magistrate, and a solicitor general. What else is next for you to accomplish?
That is a difficult question. It may appear as an easy one. It's difficult because I believe, I'm looking towards a bright future.
You can tell me you want to be the Chief Justice?
Yeah. I'm looking, perhaps what I want, Dr. Rose, is to have a PhD like you. That is all I'll say.
I'm asking about the legal profession.
I like what I do. Every lawyer has aspirations to become senior counsel. I'll say I like what I do, perhaps expand what I do. And obviously, I'm working too and getting where you are academically. So those are some of my projections for the future.
I should also say you're also a lecturer at UG. So I'm saying to you, legalistically, along the legal lines, what else you need to achieve?
Timothy, you want to help me out? I have no, if it is you're thinking about the bench, I have no aspiration right now to go on the bench. So that what I would want, though, I believe in service. I believe in service to Guyanese, and that is something, as you pointed out, I believe that I received that kind of teaching and discipline since at President's College. And what I would want is serve Guyanese even more. I have a practice in Berbice, I have one in Georgetown. I try to serve the students at the University of Guyana also. And what I would want is perhaps expand the manner and the way in which, I try to serve my people.
Charles, over to you. I know now that Ms. Kai don't want to answer the question, but that's okay.
And the discussion is going on so beautifully. Time is running out on us. I agree with Tim when he talk about, I think the judiciary, the legal mind should elect their leaders, whether it's the Chief Justice, the Chancellor, and so on. Because I think the Medical Council in Guyana has that formula that the doctors vote to elect the Medical Council, and the council runs the affairs of the doctors in Guyana. So I think in that context, I think, Tim, you're on ball. Quickly, I know we have very limited time, and we talk about the Constitution, but let's forget about the parties supporting or not supporting. If there is one article in the Constitution that you would like to change, what would that article be? Tim, we can go with you first.
People like to talk about constitutional reform and that kind of thing in vague and abstract terms. I'll tell you, for me, for the most part, although it's too bulky and unwieldy and has a lot of feel-good clauses that don't have legal effect, the changes I would make are not as substantial as many might believe. But one change I certainly would make would be to ensure that when you run for parliament, you are appointed by the people in your constituency, so you're answerable directly to them, rather than appointed by the leader of your party. There needs to be direct accountability to get rid of that abject obedience to the leader and king at the top of the party. That takes away independence, it takes away free will, it centralizes power, it encourages corruption. So for me, the one change I would make is to restore a system where you appoint your members of parliament directly, rather than allowing the leader of the party list to do so.
And before Ms. Kite answer her question, does that mean that the person must have 50% and more of the vote in that constituent, or it doesn't matter what percent you get? If you get the most vote in the election, you win the seat?
To me, it shouldn't matter. Once you get the most votes, you win the seat. Okay,
Ms. Kite, which article would you change if you had to change one?
I would go straight to the methodology in terms of how the Chief Justice and the Chancellor, how those offices are appointed. I would go straight for that. If I could change that tonight, I would do that.
Beautiful. Should we have a unicameral system parliament as we have now, or should it be a bicameral parliament? Ms. Kite?
I don't understand those fancy expressions. You want to use simpler language so everyone can understand, including your listeners?
Ms. Kite can break it down. Should we have a single system as we have now, or like the one in the US where there's two layers of parliament?
It means a parliament, a member of parliament, and a senate.
Something like that.
Yeah, close to what we have in they have in the US.
Jamaica has that too.
Yeah, I don't know. I don't want to readily say that is the direction we should go in, because obviously you have to review, consequences, advantages, disadvantages. But perhaps it is an issue which we could, look at and perhaps put to the people. To me, some of these changes and some of these, you need wide consultation, if not necessarily a referendum, but at least wide consultation. So that is an issue which can be put to the people too.
Okay. Tim, should we have a non-executive president with an executive prime minister?
I think that the larger question is exactly what we're talking about, simplicity. So you asked about two houses. You got that in the States. You got Senate and Congress. I think they do the same thing in Barbados and some of the islands. Look, we got 700,000 people. We're small. We need simplicity. We need a small government that every man on the road understands. Right now, average man on the road doesn't understand the system by which the mayor of Georgetown is elected. He doesn't understand why it is that the person who sits as representative of Linden doesn't even live in Linden and is not answerable to the people of Linden. We have to simplify this thing, and there's no excuse for not simplifying it because we're not 300 million people, we're 700,000. So we need one House of Parliament. It doesn't need to have 65 people, it could have half that number. But they need to be appointed on a constituency system so that they're directly answerable to their people and not answerable to the great leader. And once you do that, it doesn't matter if you have an executive president.
Okay, point taken. Should we remove the power of the president to appoint constitutional bodies?
Every single statutory body, every single constitutional body should be appointed by both sides having a say and a third group, whatever that third group is, having the swing vote. Now, we have to avoid fallacies and we have to avoid giving pretty labels to groups and pretending that they're independent. People talk about the Private Sector Commission. Historically, the Private Sector Commission has not been independent, it has been biased one way. So to say two sides and enter any Private Sector Commission doesn't work. People talk about the trade unions, but each of the trade unions has been biased one way or another. So we have to cut through the noise and find a way where both sides have a say in these appointments and both sides are represented. Or else we will have more oil blocks being sold without anybody knowing. We will have more house lots given away without anybody knowing. We will have more signing bonuses without anybody knowing. Both sides got to be there throughout.
Thank you, Tim. We're running out of time, Ms. Kite. Do you propose that the format of the Elections Commission be changed?
Okay, now the Election Commission has many issues. Format in respect of, because there are many issues. Which particular format you're talking about?
Well, let's talk about the body that governs the commission, the Elections Commission itself, the commissioners and the chairman.
No, I think the Constitution, I believe, is very clear as to how that body should work.
No, I know. Do you think that should be changed? Do you think the format should change?
No, the only thing that could be changed is based to ensure persons do what they're supposed to do. Ensure that persons act, in a professional manner in the dispensation of their duties. Those are perhaps, the framers didn't think that they would need to put rules and, in place for things like that. But in terms of changing, that type of change may be required.
Ms. Kite, we can go on. Discussion is really interesting, Mr. Jonas, but we have to call it today. Dr. Rose, anything before we close?
Yes, I want to say, for a memorable, pleasurable dining out, visit the Nest restaurant. Yesterday, myself, Charles, and a few other friends, we were there. And believe it or not, we spent 6 hours there. We did not want to leave. So I'm inviting all of you, our viewers, to visit the Nest restaurant located at 125 17101 Avenue in South Richmond Hill. For reservation or takeout, you can call 718-847-4035. That's 718-847-4035. Visit the Nest restaurant and you will never ever forget the pleasure of dining out. Now, one final question to both of you. What do you think you all will do to improve the legal system in Guyana? Or what should be done to improve the legal system in Guyana? And that's a short question.
More judges.
More judges, okay.
Yeah.
More judges
and more assistants.
More judges.
And
Okay.
more assistants for them.
Okay, and to you, Timothy and Miss Kite, I think that Rose is inviting you to come to New York. Call him and he will take you to the next restaurant.
Next restaurant.
But I hope you come along.
I'll remember that. Dr. Rose, I'll remember that.
Great.
All right, Tim and Kim, I really want to thank both of you for being here tonight. And there's so many other questions, but of course, time has run out on us. We want to thank you so much for spending an evening with us, to Dr. Rose, to our audience out there. I think the audience was very attentive tonight. They like what you were saying, and we hope and we pray that what you guys talk about our system of the justice system will improve. As you said, with more judges, like Trinidad next door has many more judges than us. Jamaica has 3 times our size. So I guess having more judges in the system will help us to go through this hurdle that we might have had. So I want to thank you both again for being here tonight. And to our viewers out there, thank you. God bless our country.
And both Mr. Jonas and Miss Kite, whenever you come to New York, just give me a call. Because Sanjeev wasn't here tonight, we're going to splurge and I'll send the bill to him at the next restaurant.
It was a pleasure.
At the next restaurant. He will pick up the tab for not being here tonight. What was that?
Thank you, Jeffrey.
I said it was a pleasure. And I was
okay, thanks.
It's been a long
it's
time.
A pleasure having you all here tonight. A very pleasurable discussion, and I'm happy that you all came on. Thanks a lot. Thanks.
All right. Take care, everybody.